Officer Dave, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Newhouse.
Good morning, Your Honor.
Hi, Counsel. How are you doing today?
I'm all right. How are you?
It's Monday. Been through the best I can. What brings you here today, sir?
I'm here on Auto Club v. LaShonda Hopkins.
Okay, I think I have her. I think we can get started.
Wonderful. Thank you.
No. Hello?
Hello,
What is your name?
LaShonda Hopkins.
We are on the record calling file number 22190-091, Auto Club Insurance versus LaShonda Hopkins. This appears to be a subrogation case. Could I have your respective appearances?
Good morning, Your Honor. Abe Newhouse on behalf of the plaintiff.
Bar number.
85687.
And what is your name, ma'am?
LaShonda Hopkins.
All right. It appears the court opened written discovery the last time we were together on this file. Requests for admissions were sent out, and the answers to requests for admissions were filed on behalf of the defendant. Did you receive your copies, counsel?
Yes, I did, Your Honor.
Okay, so both sides have them. All right. Where are we on our other written discovery? Are we completed, or is there more that needs to be done?
The written discovery is completed, Your Honor. There is a question of fact. Ms. Hopkins answered our discovery timely. It was great. She indicated that she did not own the vehicle on the date of loss. She did tell our investigator that she owned the vehicle on the date of loss previously. So we have a question of fact there. And honestly, Your Honor, I think the easiest thing to do would be to depose her and possibly the underlying claimant. And we could limit it to an hour or a half hour and just figure out who owned the vehicle. Because it's clear that the vehicle was uninsured on the date of loss. And we need to figure out who owned it if Ms. Hopkins didn't own it.
Ms. Hopkins, it is your position that you did not own the vehicle at the day of loss?
No, I didn't.
Somebody else owned it?
Yes.
Okay.
I,
What do you want to tell me, ma'am? What do you want to say? I mean, is something else you want to say, ma'am?
no,
Okay. First of all, let me ask whether or not you intend to do any written discovery yourself.
I just personally didn't know how to go about it. I just found out like it was just a questionnaire. I just thought I just had to file and answer their questions.
Well, yeah, but you have the right to ask questions of your own. You have a right to request production of documents. You have the right to send interrogatories, which are written questions that have to be answered. You have a right to request for admissions like the ones you answered. Just because they send them doesn't mean you have a right to do that too. You understand?
Yes.
Okay, so I don't think she's ready to make a decision on that one day, one way or the other. Who is the other party that you want to depose, Mr. Newhouse?
That would be the underlying claimant, Ms. Hayes.
Okay, before I make a decision about the deposition of the defendant, the court is going to authorize you to take a 1 hour, 15-minute deposition of the name again.
Antriel Hayes.
All right, you submit an order to that effect. And
Yes, Your Honor.
obviously you have to subpoena. Ma'am, you have a right, Ms. Hopkins, when this deposition is noticed, you have a right to attend that deposition and to ask questions of the witness, just like Mr. Newhouse does. You understand?
Yes.
Okay. So what I'm going to do is I'm going to give you guys a return date. The next day with me will be October 17th, October 17th at 10 o'clock. Does that work for everybody?
Yes. In the meantime, I'll make a written discovery. I
You
can
have the
ask.
right to, your written discovery remains open, ma'am. Yes, ma'am. You have the right to do the interrogatories, the right to do requests for productive documents, requests for admission, just like he has.
Okay, yes.
All right, Mr. Newhouse, I'll look forward to that order concerning
Your Honor.
the position of the witness, and we'll see you guys again October 17th at 10 o'clock, and your written discovery remains open. Is there anything else we can accomplish today?
I don't believe so, Your Honor.
Anything for you, ma'am?
No, sir.
Okay, we'll get your notice, October 17th at 10 o'clock. You have an hour and 15-minute deposition of that claimant, and let's get that order into the court as soon as possible. Thank you both for coming in. We are off the record.
All right. Thank you, Your Honor.
All right, let's be safe out there.
Thank you.
Hello?
Good morning, Your Honor. Elizabeth King, P 74979.
On what?
This is Mackenzie versus Auto Owners.
I think I have Mr. Myers here. Mr. Myers,
Hi, good evening, Judge.
this is 22-190-076.
Yes.
Martha McKenzie, Ryan McKenzie versus Citizens Insurance. Your respective appearances, please.
Good morning, Your Honor. Elizabeth King appearing on behalf of the plaintiffs, Mackenzie, P 74979.
Good morning, Your Honor. Mitchell Myers, appearing on behalf of the defendants, P 82917.
All right. This is our second pretrial. When we were last together, the defendant had not made the 2.3028 disclosures. Were those done?
Yes, Your Honor, they were.
Okay, you have those, counsel?
I do.
All right, now, what are we arguing about here? What's the amount of money in controversy?
It's $25,000.
Yeah. You see my concern.
Yes, Your Honor. And we did discuss this at our last pretrial. The policy limit, this is an endorsement to their homeowners policy, is $25,000.
That's the maximum claim under the contract value of the endorsement.
Correct, Your Honor.
Okay, now, what is the basis, the nature of our dispute here? This is a
So-
property damage claim. Is that what's going on here?
Yes, Your Honor. This is, as you may recall, in June of 2021.
Flood.
Yes. So, well, it was a water event back up through their drain in their basement that caused significant damage, and their claim was denied. And we are just pursuing their rights under the policy for
Okay,
payment.
let me ask you this. I know just from watching the television
Mhm.
that Detroit Water and Sewerage was making some offers in these claims. I don't know whether you've made such a claim with them or not. I don't know if it's too late to do so, but it might be something to consider.
I appreciate that, Your Honor. And I believe that they did, my clients did do so, and that claim was denied. They did also make a claim with FEMA. FEMA did pay them a portion of their loss, but this $25,000 remains outstanding.
So your position is that your client's loss exceeded $25,000 even after the FEMA payment.
Correct.
Okay. Mr. Myers, what's going on here?
Yeah, Your Honor, our position is that there's a clear concurrent causes clause inside of the contract that denies coverage in the event of any superseding or intervening causes that would cause damage. The plaintiffs in this case left a window open in their basement, or a window was left open in the basement, and water and mulch and other debris was able to enter the basement through that gap. Excuse me.
So what we're looking for is declaratory action then, which ought to be brought into circuit court. Has that been filed?
I'm not aware, Your Honor.
Because if your claim is that if you're claiming that there's a policy, that's typically a declaratory action done in circuit court. But what do you need in the meantime to get your file moving here?
Well,
Go ahead. I'm sorry, you go ahead.
No, that's fine. When I spoke with Peter O'Toole, who's also counsel on this matter previously, he had mentioned that he believed he may need to do some discovery. So perhaps further counsel is aware of that at this moment. I mean, our position is pretty clear cut. We don't necessarily need discovery. We would like to just have an opportunity to resolve it. But of course, the insurance company is the one with the money, so they may have other thoughts.
They seem to be the ones with the pocket.
Yeah.
What are you talking about in terms of discovery, Mr. Myers?
So we're looking at getting an expert witness in this. We need to determine, or rather there's a question as to how the water actually entered the premises, whether it came up through the drains or whether it actually flowed in through the window or both. And that's kind of what's at issue here.
So what is necessary for your expert witness to opine in the case? He has to make an inspection of the premises? He
Yes.
has to read documents? I mean, what is it?
Yeah. So we would definitely need an inspection of the premises, and then otherwise we have documents that we need in terms of photos and of that sort already.
All right, so the only thing that we need to get your expert at a position where he can make an opinion is an opportunity to inspect the premises. Is that right?
Yes.
You have any objections to that, Ms. King?
No.
All right, so here's what we're going to do. I'm going to give you guys another date. It'll be October 17th at 10 o'clock. By the time I see you next, you will submit a joint order providing a date and time for the inspection by whoever your expert is going to be. So we'll have some understanding at that point following our pretrial, what, if anything, we need to do going forward. Is there anything else we can accomplish today?
Your Honor, if I just may have some clarification, are you saying that the inspection should occur between now and October 17th?
No. What I'm
Okay, just-
saying is I'm giving you an October 17th pretrial date. And by that time, I expect to have in my file a stipulated order from you two saying the premises located at 12345 Brown Street will be inspected by Dr. Freddie between the hours of boom and boom on such and such a date.
Thank you.
Anything
you,
else?
That's about it for me, Judge.
Okay. Anything for you, Ms. King?
No, thank you.
Now, my next question, and again, this is not a give me an answer today day. This is not that kind of question. We are coming up on the end of the year. It's been a while since I was on your side of the road, but my recollection is files seem to get resolved at year end. So what I'm suggesting that you consider, and do not give me an answer today because I don't want an answer, is when you get this, we get our together the next time, consider also the possibility of resolving this by a binding arbitration. It'll probably be more, it'll certainly be less expensive and probably be faster than any other route. Again, not a decision to be made today. All the things we're going to do today, we're going to come back October 17th at 10 o'clock. You're going to have in my hot little hand the order for inspection so that we will know when to schedule our next pretrial after the expert witness has had his opportunity or her opportunity to examine the premises. Anything else we can do today?
No, thank you.
Anything for
So
you?
thank you, Your Honor.
Okay, we send out an order. I'll look forward to seeing October 17th at 10 o'clock. Thanks for coming in.
Thank you.
Thank you.
Be safe out there.
You too. Thank you.
Second of three are Pesco Streets based on old new pieces. Both are even on the speeding. I went to 1923, 6 years into the process. Francesco Vecchio, city officer of WRCJFM. They can't help you. We are classical jazz, we are all music station. So very.
Council, good morning.
Good morning, Judge. How are you today?
Not bad for a Monday. How are you?
Pretty good.
What you got?
579 CKS Prime versus Gatlin.
Okay. I don't have Mr. Gatlin as of yet.
Okay.
So off to the waiting room with you.
Thank you.
Good morning, Your Honor.
Hi, Mr. Asher. How you doing?
I'm fine. How about yourself?
Okay for a Monday. You got Global Care versus City?
Yes, I spoke to the attorney this morning, so he should be appearing.
Okay, I don't have him as of yet, but I'll put you back in the waiting room.
Thank you.
The Darrells and Nate are a pair. 115. Mr. Nates, Mr. Darrells, good morning.
Good morning, Your Honor.
This is 22-184-115, Citibank versus Deborah McGowan. Your respective appearances, gentlemen.
Preston Nate, P77884, appearing for the plaintiff Citibank.
Michael Leonardo's P62114, appearing for the defendant, Deborah McGowan.
Gentlemen, this is our second pretrial. How are we doing on our written discovery here?
Well, an update to the court. Happy to report that we did get a settlement kind of worked out. I sent the proposed consent judgment over to Mr. Leonardo. So I think we're just kind of waiting for some signatures, but everything should be pretty resolved, I think, once that gets done.
Counsel?
I believe that's your case, Your Honor. We have a consent judgment. My client has given approval to sign for it. I believe we've resolved the matter.
All right, so what I'll do is I'll give you guys a return date of October 17th at 11 o'clock. Hopefully by that time, the paperwork will have caught up with the file. The judgment will be entered and there'll be no need for you to appear.
Sounds good.
Okay, guys. let's be
Thank you.
Thanks for coming in.
Thank you.
We're all-
Thank you, Your Honor.
Come back anytime you want to settle.
Thank you. Bye.
Thanks, Mike.
Mr. Lowe,
Good morning, Your Honor.
Mr. Asher, good morning, gentlemen.
Morning, Your Honor.
We're ready to go on case number 22-190586, Global Medical Care versus City of Detroit. This is our first pretrial on this provider PIP case. Could I have your respective appearances?
Good morning, Your Honor. Jamie Lowe on behalf of the plaintiff. My P number is 63110.
Good morning, Your Honor. Alfred Ashe on behalf of defendant PA 2536.
Okay, we got a provider PIP case. Mr. Lowe, how much is your claim here?
I'm pulling it up right now, Your Honor. Let's see, 190536, I believe. Oh, 586, 190586.
586.
The amount in controversy is $4,135.
Okay, so no question about exceeding my subject matter jurisdiction.
Correct.
Have you done the 2.3028 disclosures, gentlemen?
I'd have to double check the file, but I believe that we both have.
Mr. Asher?
Yes, I believe that is correct, Your Honor.
Okay. So what's our hang up then? Small amount
Well,
of
I mean, we're just
disclosures have been made. Let's get moving, gentlemen.
Mr. Asher and I have a lot of cases together. In fact, I'm sure we've been in front of you collectively several times. We tend to get these resolved. We just need to start the dialogue, and then pretrial conference is a good time to actually start that happening.
Okay. So what I'll do is I'll give you guys a date. October 17th will be our next date at 11 o'clock. Does that work for everybody?
Yes,
that works for me, Your Honor.
Okay. Mr. Lowe, that works for you?
it does, Your Honor.
Okay.
And what time?
11 o'clock like today.
Okay.
You guys are off to a chat room. Get the case settled.
Well, we'll certainly work on it.
Come back to me if you finish. Otherwise, October 17th at 11 o'clock. Okay?
Okay.
Thanks, guys.
Thank you, Your Honor.
Be safe out there.
Yes.
All right. Alfred Ashe assigned to, where'd he go? Jimmy Lowe assigned to room 2.
If he left, I've got his cell phone number, so we can
he
always
left.
chat.
He seems to have left. So
I have his cell phone, so I can call him right now. if
call
that's
him
okay.
up.
Okay.
Thanks. Be
Thank
safe.
you. Yep.
for WRCJ is provided by the Tim Stamp Speaker Series, presenting Michelle Okadona, whose work includes drawing, public art, functional objects, video, and more. Okadona's artistic vocabulary is fueled by a lifelong study and appreciation of the natural world. Her talk, Carrying Golden Threads, is a live event Thursday, September 5:30 p.m. at the Michigan Theater. Learn more at pstampsevents.org.
This is WRCJ FM. Back to the US.
Hello,
All right, what is your name?
Jimmy Gatlin.
Okay, we are on the record. This is 22-188-579 CKS Prime Investments versus Jimmy Gatlin. This is our second pretrial on this case, which involves a claim of a personal loan. Your respective appearances.
Good morning, Your Honor. Attorney Ashley, known as P77029 on behalf of plaintiff.
And what is your name, sir?
Jimmy Gatlin.
Is it your intention to continue to represent yourself in this matter?
Yes, Your Honor.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind Ms. Nunes will be binding on you. You understand that?
Yes, Your Honor.
Where are we on this file, people? I see the plaintiff has filed a motion for I'm sorry. This is our second pretrial. Where are we?
You're correct, Your Honor. We have filed our motion for summary disposition. There's been no resolution, no responses to our discovery, as well as no response to our motion. So we would ask for a hearing date on our motion.
Mr. Gatlin, are you intending to do any written discovery, sir?
Yes, I was intending, but the person that I had went into the hospital last night into emergency. And so
I guess I'm not understanding how that's relevant since we were last together back on August 22nd. And your written discovery has been open in this file since July 26th.
Yes, Your Honor.
This person, what is this person? Is this an attorney who's going to file an appearance in the case?
Yes. It's my wife.
Is she an attorney licensed to practice law in the state of Michigan?
No, sir, but she's a pre-legal. And I was
She's not an attorney.
Okay.
All right,
Yes,
here's
sir.
what I'm going to do. I'm going to continue written discovery until our next pretrial. That next date will be October 17 at 11 o'clock. The discovery will close October 15th. So when we're together next time, any discovery that has not been done will not be getting done. On that date, Ms. Nunes, we'll be calendaring your motion for summary disposition.
Okay.
Does October 17th work for everybody, 11 o'clock?
Yes.
Yes, Your Honor.
All right. Anything else we can accomplish today?
Your Honor, do you want me to send out a notice of hearing for that motion, or is this adequate? Because I know. Okay.
It's not set yet. I'll set that date on the pretrial date.
Okay.
All right. Anything else we can accomplish today?
All set.
Mr. Gatlin.
I'll set, Your Honor.
All right. Thank you for coming in. We're off the record. Let's be safe out there.
Thank you, Your Honor. You too.
Thank you, Your Honor. You too.
Thank you.